Should I begin? Okay, good afternoon. Welcome, everyone. Thank you for joining us today in what I expect will be a really fascinating discussion about some of the most pressing issues facing freedom of expression around the world, and importantly, the legal foundations for those rights and where they are most under threat, all with a panel of legal experts. In this panel, we are going to discuss trends, the current status of protection of these rights, and the threats that we are seeing from hostile regimes and digital surveillance. We will discuss the importance of protecting journalists in a democratic society, and in particular, the growing intimidation, repressive laws, and violence, the criminalization of speech, and also the future challenges to the freedom of expression, including from digital tools and artificial intelligence. My name is Kaiser, and I'm the General Counsel of the Associated Press. We have journalists reporting from around the globe, and often in the most difficult places and situations, where they face suppression, surveillance, intimidation, detention, and even violence simply for doing their jobs. They face severe criminal consequences for reporting on topics that many governments would rather suppress. And restrictive laws exist globally that try to silence this reporting. In my role, I fight for press freedoms and protect our staff against such laws and consequences wherever possible. But as everyone here knows, these problems exist around the world. Last year alone, we had reporters jailed in Myanmar and Ethiopia, and countless others detained and harassed, equipment seized and destroyed. Freedom of the press and freedom of expression is a prerequisite for a democratic society. And so we believe very strongly in protecting those rights. This discussion is very important to all of us, but also for all journalists and press advocates and around the globe, and most importantly to the people of the world, the citizens who benefit from this critical information. We have a very distinguished panel here today to talk to us about these rights, and I have the distinct honor of presenting them and asking them to say a few words of introduction about themselves. So if they're available, I would first like to introduce the Honorable Ricardo Pérez Manrique, President of the Interamerican Court on Human Rights. If you might say a few words, please.
A todos y a todas.
It's an honor to participate in this event. We've sponsored on jurisprudence of the 3 regional courts working in the world in relation to freedom of expression. My greetings to Ana Maria Guerra Martinez from the European Court of Human Rights, Aymana Urabu, President of the African Court of Human Rights and People's Rights, because I think it's extremely important that the courts, since 2018, have been conducting common actions to progress in line to deepen the dialogue among our courts to improve the ruling of human rights in our continents. Greetings, warm greetings. We hope to see you in 2023 in San Jose, Costa Rica for the next intercourt meeting we must conduct that year in San Jose, Costa Rica. Thank you so much.
Also participating today we have the Honorable Lady Justice Mani Daoud Aboud, President of the African Court of Human and People's Rights. Your Honor, would you kindly introduce yourself as well?
Thank you very much. I'm Iman Aboud, the President of the African Court of Human and People's Rights. This is not the first time for the African Court to participate in that. It's the matters pertaining freedom of speech and liberty of journalists. So it's just a continuation of what has been started, and last year we participated in Nairobi. We hope for that even today's discussion will be fruitful, and it is a continuation of the struggle to make sure that the commitment to make sure that freedom of expression, freedom of speech, and the liberty of the journalists have been complied by most of the states or countries in the world, and they are respected. Thank you.
Very much. And also with us today, the Honorable Ana Maria Martins, a judge elected from Portugal to the European Court of Human Rights. Your Honor, would you kindly introduce yourself?
Thank you very much. As you know, I am here on behalf of the President of the the European Court of Human Rights. I would like, first of all, to congratulate all journalists for the extremely valuable work they do in the world in order to reinforce the democratic society. And I'd like to greet all the colleagues that who are here in this panel and their courts. I think that it is very important to have this judicial dialogue, and in my view, the judicial dialogue is the main aim of our lives as judges. So I am judge at the European Court of Human Rights. I am a former judge of the Portuguese Constitutional Court, and my professional life is full professor at the Law School of the Law School of the University of Lisbon. So I am a mix of academic and judge. I have both things. Thank you very much.
Participating today. And before we begin, I would just like to invite the audience to submit questions either in person or through the chat function. So with that, let's start with our first question. I would like to ask the panel for their overall assessment of the level of protection to press freedoms that they believe exists in their respective regions, and whether we are seeing a trend or a growth towards enforcing that freedom of expression or a trend to limiting it. If we can start, Honorable Ricardo Pérez Manrique, if I can please ask you to start this discussion for the Interamerican Court and Region, please.
Good. I believe that the level of protection of freedom of the press and of expression in the American continent has experienced very significant developments through the jurisprudence of the Interamerican Human Rights Court, particularly in 2021. We have had 3 sentences. One, in the case of the journalist Ginette Benocia Lima from Colombia, who was kidnapped, tortured, and raped on occasion of conducting investigation, research, journalism in relation to the paramilitary in Colombia. There, the court established the rule of the 3 Ps, necessity to protect, the necessity to prevent, and the need to bring justice for crimes against journalists. Then we dictated a sentence in the case of Urrutia. And I'm sorry, we're having and the right to honor and the criminal prosecution in relation to a public official. There, the courts indicated that we couldn't resort to the penal law, that it could not be admitted in order to repair the honor of the official when we're speaking of personal actions in the exercise of his function. Then the case of Maja and Guatemala, this related to a matter of the plurality of media and for the originary people to have the chance to access community radios to convey their beliefs and language. I must add that the court, since 1985, in its first pronouncement on the freedom of expression, has sustained that freedom of expression is mandatory for the existence of democratic society, to have a free democratic debate, and the importance of the task of journalists as agents enabling the effectiveness of their own freedom of expression and the freedom of individuals to access all the necessary information to have an opinion, and in this way access to a democratic debate. We believe that today, as the call for this seminar states, we have a journalism under siege that is related to the attacks, for example, via the social networks, but other assaults impacting on women journalists particularly, and harassment is an issue particularly for women and journalists in general to try to silence them. Here, there is a demand for more protection to journalists. We are considering proposals such as the need for special laws for protection to journalists to avoid that violence or different sorts of expressions may result ultimately in the worst effect, that is to bring fear to journalists so they have self-censorship and are silenced.
In our continent, unfortunately, there are many journalists who have been murdered, and there's great impunity in these crimes. And something that I find important to stress, the fact that journalists who have been displaced for fulfilling their role, they are forced to relocate, to move from cities, even sometimes move out of their country to protect the integrity of their family and their own individual protection, and they are threatened and at risk due to different powers at play. Let me close by saying that without journalism, without serious and research journalism, it is impossible to succeed in our fight against corruption and organized crime. And that's why the IHCHR considers this topic to be a priority. And once again, all of our sentences build safeguards with a human rights perspective for the work of journalists, raising awareness on the need to protect and avoid the pressures that they are faced with in fulfilling their roles, and avoid these threats and actions against their lives and personal integrity of people, of journalists. Thank you.
Detail in a little bit. I would like to ask the Honorable Lady Justice Imani Aboud, if I might ask for your overall assessment, please, of the level of protection for freedom of expression in your region and in your court.
Thank you very much. First and foremost, permit me to recognize the leadership of UNESCO, various officials of our host government of Uruguay, colleagues of the European and Interamerican Courts of Human Rights, media rights, civil society, and media professionals, as well as distinguished members of this panel. When it comes to Africa, which is the jurisdictional space of the African Court, the state of freedom of expression and related liberties is inevitably apprehended through the prism of democratization and the bargaining of past 1990s constitutional democracies. It is largely accepted that freedom of expression is the fourth pillar of democracy in its originating sense of the government for the for the people in Africa, of the people and by the people, as a derivative of democracy, freedom of expression, therefore vests with the citizenry the inherent right to criticize and ask the state to function properly and work as it is obliged. These principles form the basis of commitment by member states of the African Union to freedom of expression under the African Charter on Human and People's Rights. And this is reflected under Article 9, sub 2 of the African Charter. As you may be aware, the African Court on Human and People's Rights is the only judicial organ which has been entrusted by the African states to enforce individual and groups' rights across the continent, including democratic freedoms such as freedom of expression, but also the right of information or right to information. As highlighted in the concept note of the event currently holding here in Punta del Este, courts play a critical role in the enforcement of freedom of expression and the right of journalism. This submission applies to not only national courts, but increasingly to their international counterparts, such as the African Court. It appears that freedom of expression, media rights, and safety of journalism encompass the effort made so far by regional courts in Africa to address the most current challenges facing free speech and the right to information. From the earlier decision of the African Commission on Human and People's Rights dating from the era of military rule in Nigeria, to the most recent pronouncements of the ECOWAS Court on the post-Jamea era in the Gambia, the African Court has judicialized the enforcement of not only freedom of expression, but also largely media right, and indeed state obligation to guarantee the safety of media professionalism. Recent case law of the African Court on Human and People's Rights reveals that freedom of expression expands beyond the right to freely exercise media profession, to embrace the much larger demand that the exercise should participate directly in the democratization by censoring public governance through free speech, as it was in the case of Ingabire Victoria Umuhoze versus Rwanda, which was decided by the African Court on merits, or assessing information, as it was in the case of Pata, Minister of Law, Constitutional Affairs and Human Rights, and others. The contribution of the African Court to the report on the protection and enforcement of freedom of expression should also be acknowledged for lending an international voice to the endeavor by national courts to guarantee free speech and the right to information. In this regard, the African Court and other such institutions have developed a legal understanding on how freedom of expression should be understood and applied across the continent. The African Court in particular has contributed significantly to this approach by enforcing safety of journalists in the well-publicized case of Norbert Zongo versus Burkina Faso. The court has similarly strengthened freedom of expression through a critical move towards decriminalization of press offenses by applying the well-established principle of proportionality, but also that of acceptable limitations to rights in democratic societies, as well as was done in the no less internationally known case of Leho Issa Konate versus Burkina Faso, which was decided by the African Court. Finally, the court has enforced a more civic approach to freedom of expression involving political context, as was seen in the matter of Ngabire Umuhoza versus Rwanda. Let me just end here now. Then maybe I can elaborate more in the due course. Thank you.
Thank you very much for your assessment. And with the Honorable Judge Martins, if you wouldn't mind, I would love to hear your assessment of the trends for protection as well in the European Court of Human Rights.
Thank you very much. I have to say that the level of protection to press freedoms in Europe is a multi-level protection. That means we have mainly two instruments to this protection. I'm only going to speak about
Deux instruments pour ceci.
Law, especially the Charter of Fundamental Rights on Fundamental Rights of the European Union, which is also very important. The Convention provides for freedom of expression in Article 10 and for safety in general in Articles 2 and 3. The European Court of Human Rights has a rich case law on the freedom of expression of journalists and their safety. In its interpretation of Article 10 of the Convention,
Sécurité dans l'interprétation des articles.
76, has held that freedom of expression constitutes one of the essential foundations of democratic society, one of the basic conditions for its progress and for the development of every man. So, Article 10 is applicable not only to information or ideas that are favorably received or regarded as inoffensive or as a matter of indifference, but also those that offend, shock, or disturbs, such are the demands of the pluralism, tolerance, and broad-mindedness, without which there is no democracy. This was something. This was said in Handyside versus United Kingdom from 1976, and Observer and Guardian versus United Kingdom in 1991. A freedom of expression is subject to exceptions, which must, however, be constructed strictly, and the need of any restrictions must be established convincingly. For instance, in Maurice versus France, we can read this idea. Article 10 of the Convention enjoys a very wide scope, whether substantially or formally, and the Court has always asserted the essential role played by the press as a watchdog in a democratic society, and it has connected the task of the press in imparting information and ideas on all matters of public interest to the public's right to receive these ideas and this information. One of the last cases where the court expressed this idea was Satakunnan versus Finland or Bede versus Switzerland. Where the freedom of press is at stake, the authorities, the national authorities, have only a limited margin of appreciation to decide whether a pressing social need exists. This is true that the examination of Article 10 by the court is a step-by-step analysis. First, the court analyzes where there was an interference with the exercise of the right of the freedom of expression, and then examines if this interference is in accordance with the so-called three tests: the lawfulness, the legitimacy, and the necessity in a democratic society. The court has developed in its case law
En la jurisprudencia y los conceptos
of the interference as a proportionate to the legitimate aim pursued. And I will come back to this, but the court is very strict in assessing, accepting the existence of this pressing social need, and in accepting the limitations to the freedom of press. I come back to this issue. There are many examples. For instance, the court is very critical to the criminal pursuing of journalists. But I come back to this in another point. I would like only to say that in Europe there are many threats to journalists because of many reasons. For instance, COVID-19 has been a threat to journalists as well, due to the fake news and things like that. But in Europe, the international courts, our court and the Court of Justice of the European Union, try to enforcing freedom of expression and not to limit that the freedom of expression. For now, thank you very much. It's what I have to say.
Thank you. Thank you for your assessments. So I would like to discuss two substantive areas. Why don't we start first with the criminalization of speech, which is a very critical area. In the landmark case in the African Court of Human and People's Rights, we had the case of Konate versus Burkina Faso in 2014, the court's first case concerning freedom of the press. The court there overruled the conviction of a journalist who faced harsh criminal penalties for publishing an article that alleged corruption by a state prosecutor. The court there found that the journalist's conviction, imprisonment, and fine was a disproportionate interference with the right to freedom of expression. And this case set the standard that by the court that government should not criminalize defamation and that no journalist should be jailed for defamation. That theme exists also in the other courts, in the Interamerican Court as well, in Palacio Urrutia versus Ecuador, and also in the European Court of Human Rights in Lingens versus Austria. So I'd like to have a discussion on the topic of the criminalization of speech, starting with this landmark case in Africa, and how the court reached that decision, what factors were most important, including whether the subject of the story as a public official was important in making that determination. And also, importantly, does this case mean that the jailing of a journalist is always invalid? Or how much depends on the circumstances of the case and might be applied differently in a different situation? So if we can please start with the Honorable Justice Aboud from the African Court to have this discussion about this case.
Donc, Madame Aboud, si vous pouvez nous raconter un petit peu plus.
We might be having some technical problems. Okay, if so, why don't we come right back to Lady Justice Aboud once that gets resolved. Honorable Maria Guerra Martins, would you like to start us off with your views from the European Court on the criminalization of speech?
Concerning the criminalization of speech, the court has a case law very settled, a very well settled case law. As I start to say, our approach is this step-by-step approach, and as we analyze case by case, of course. For instance, we consider that criminal conviction, a fine, an imprisonment, in order to pay the damage, a conviction, even where this execution is suspended, even the investigation in criminal proceedings, all these interferences are interferences that they are really it is very difficult to accept that they are necessary in a democratic society, because these three tests I've already mentioned, we assess first if the interference is lawful. It can be that it is lawful because states can approve whatever they want, or almost whatever they want. We assess if there is a legitimate aim, and sometimes there is this pressing social need, and the court gives a very broad margin of appreciation to the states to evaluate if there is this need or not this need. But the problem is the necessity of the interference in a democratic society. And when it comes to analyze this issue, the court is particularly attentive to the censorship aspect of the interference, and must be satisfied that this offense and this penalty, if there is a penalty, does not amount to a form of censorship intended to discourage the press from expressing criticism. And when when there are convictions of a journalist, for instance, prior to the publication, the court's view is always that there is a censorship. The problem is that usually I can quote Beda versus Switzerland, I can quote Urper and others versus Turkey, or Gozel and Ozer versus Turkey. The problem is that the freedom of press usually is in conflict with other rights. And there is necessary to establish a fair balance between freedom of expression and right, for instance, to respect for private life or reputation or other rights. And the court, in order to establish this fair balance, there are 5 criteria. The contribution, the court assesses if there is a contribution to a debate of public interest, the degree of notoriety of the person affected, and the subject of the news, the prior conduct of the person concerned, and the content, form, and consequences of the publication. It is the assessment, the point of departure of the assessments are these criteria, but we are a court of the case. We are not a court to assess laws, or so we have a case-by-case analysis, and some criteria may be more important in a case than in other. So there is, for instance, the way to obtain information. If the information, because for us the journalists, they have also duties. To a certain extent, the journalists have also responsibilities. The job they have is so important to the democratic society that they have also some responsibilities, and it's not very easy to transpose the criteria from a case to another. One of the last cases, Satakudan versus Thailand. In this case, the court considers in each case whether the criteria may be transposed to the case in question, although certain criteria above may have more or less relevance given to the particular circumstances of the case. So sometimes some criteria are more taken into account than other, depending of the particular circumstances of the case. If there is, for instance, in the case Axel Springer, which concern a trial for murder and the ban on publication of images in which a defendant could be identified, the court had the new criteria, the influence of criminal proceedings. This is also important. When it comes to public entities or public individuals, the status of this individual is very important. Political and public figures, they have to accept more criticism than the individuals who are not in public stage. So the politicians, the public figures, for instance, members of government, members of parliament, and even judges, they have to be open to criticism. In the case of judges, we have a very interesting case law, because the court must also protect judges nowadays. It is not only necessary to protect journalists, it is also necessary to protect judges. As everyone knows, the threats to the independence and impartiality of the judges are also a problem. So there are permissible limits. There are limits not in a theoretical and general manner, but in concrete. And we accept that the protection of the profession of judge is also something that has to be taken into account. I think for the moment it's what I have to say in answer to this question. We have many cases. We have all the cases about ministers and about political figures. The first one was what our moderator cited, Lingens versus Austria, but we have much more. For instance, Tusalpa versus Turkey, Brasilia versus France, Tuan versus Turkey, Mladina versus Slovakia, Monica Macovei versus Romania, and so on. We have also these cases, very interesting cases against Spain, and there is a very interesting case about the King of Spain, and the court in this case considered that although the king is a public figure, he occupies a neutral position in political debate and acts as an arbiter and a symbol of the state unity. He should, the criticism against him in the exercise of the official duties should not overcome the certain limits. This is Otegi Mondragon versus Spain. I think for the moment it's what I have to say. Thank you very much.
Thank you. Thank you very much for that really useful explanation. And what you mentioned about a public official being subject to more scrutiny, I believe was absolutely the part of the reasoning in the African court's case in Burkina Faso. So if I might ask Lady Justice Abu to speak about that case and the criminalization of speech in the African court.
Thank you.
Thank you.
Can you hear me?
Yes, perfect.
Thank you very much. Regarding the case of the Konate's case, the court in its decision was of the view that for restriction to be accepted, that there must be restriction to serve a legitimate purpose. That was one of the conditions which was considered by the court. And the court was of the view that for restriction to be acceptable, it does not suffice for it to be provided by law and be written with precision. It must serve the legitimacy. And there were other restrictions, that restriction must be necessary to achieve the set objective, that there must be the objective set to achieve. And under that, the court had to raise two issues of burden of proof, of which the principle of necessity and proportionality, basing on itself on international jurisprudence. That is of the African Commission on Human and People's Rights. and the United Nations Committee on Human Rights, European Court on Human Rights, and the Interamerican Court. The courts first held that the restriction on freedom of expression should be absolutely necessary in democratic society and meet the criteria of proportionality. The issue of whether a certain person who has been accused to commit that offense, that is maybe the journalist, is a public figure, was also considered in this case by the African court. And under this, the court ruled that the sentence relating to defamation, as it is inconsistent with the charter and the covenant, the covenant and the revised ECOWAS treaty, of which the enforcement of law of Burkina Faso also amounts to violation of relevant human rights provision in that regard. And the court said, of course, the journalists or any professional professional journalist who is the public figure, he's prone to a lot of criticism by any state. And being that the court had to consider that the Konate, this case of Konate and the applicant was convicted or was held liable by the High Court up to the Court of Appeal wrongly, just because, and these kind of people need to be protected more just because of the status they hold in their countries. And that's why the court established this principle that we in deciding these cases, number of issues need to be considered. As I said, first we have to consider the court has to consider the principle of necessity and proportionality. Second, the principle of proportionality as applied to public figures. And the court then relied once again on international jurisprudence and held that in assessing the criteria for proportionality, it must particularly take into account the fact as to whether or not the person whose interests have to be protected is public figure in the given society, as it was in this case. And in this instance case, the courts noted that the prosecutor of the public was certainly a public figure who must be subject to more severe criticism than an ordinary individual. And the court considered that there's no doubt that a prosecutor is a public figure as such. He's more exposed than an ordinary individual and is subject to many and more severe criticism, given that a high degree of tolerance is expected to him or her. The law of state parties to the Charter and the Covenant, that is the ICCPR, with respect to dishonoring or tarnishing the reputation of public figure, such as the member of the judiciary, should therefore not provide more severe sanctions than those relating to offenses against the honor or reputation of the ordinary individual. Also, the court considers the principle of proportionality as applied to custodial penalties. In this regard, the court stated the general principle that offenses against the law of freedom of expression and press freedom should not be punished with the penalty of imprisonment. The court also, considering therefore the specific issue of custodial sentence prescribed by the Burkina Faso legislation for defamation, the court again based itself on international jurisdiction and concluded that in that case, the imprisonment penalty provided for does not constitute a necessary restriction to freedom of expression. And in its operative part of its judgment, the court anonymously upheld the said violation and went further to order the respondent state to amend its legislation on defamation in order to make it compliance with Article 9 of the Charter and Article 19 of the Covenant, the ICCPR, and Article 66, sub 2 of the revised ECOWAS Treaty by repealing custodian sentence for act of defamation. Then it went on exceptions to this proportional nature of imprisonment penalty. After affirming and apply the principle according to which the penalty of imprisonment is disproportionate in matters of freedom of expression, the court all the same took care to specify that in certain exceptional cases, custodial penalty could be legitimate, such as in the event of serious and very exceptional circumstances. For example, incitement to international crimes, public incitement to hatred, discrimination or violation, violence or threats against a person or a group of people because of specific criteria such as race, color, religion, or nationality. And lastly, the court also considered the application of the principle of proportionality to non-custodian penalties. Okay, that is not last. The last one is F, of which I'll be very brief on this. It's a long explanation. As regard to non-custodian penalty, the court first indicated in the operative part of its judgment by majority of its members that the existence of the sanction in question in Burkina Faso law does not in itself tantamount to violation of Article 9 of the Charter and Article 19 of the Covenant, as well as Article 66, sub 2C of the revised ECOWAS Treaty. Consequently, in the operative part of its judgment, the court anonymously ordered the respondent state to amend its legislation on defamation in order to make it compliant with Article 9, as I said, of the Charter and Article 19 of the Covenant, as well as 66 of the ECOWAS. Another principle which was considered by the court is application of the principle of necessity and proportionality to the action taken by the Burkina Faso court. Well, I'll be very brief on this, and its operative parts, after considering many other things, the court concluded that the respondent state violates Article 9 of the Charter and Article 19 of the Covenant because of the excessive fine, damage, interest, and cost, and the measure suspending the weekly organ for a period of 6 months. Also, they considered the issue of burden of proof of where although the issue of burden of proof to justify the restriction to freedom of expression was not explicitly addressed by the court, The latter implicitly decided on the matter. And in concluding that there has been a violation of freedom of expression or freedom or press freedom, the court relied in particular on the fact that respondent states could not show that the restriction to freedom of expression imposed by the legislation and enforced by its court fulfilled the criteria of necessary and proportionality, as I discussed above. And then the conclusion, therefore, made in the view of the court, the ultimate burden of proof of the legitimacy of the restriction to freedom of expressions fall on the respondent state. The applicant should, without doubt, adduce evidence to the effect that the restriction in question are not justified. But in the final analysis, it is the proof presented by the respondent state that will determine the outcome of the case. That was what was considered in Konate, even if there are other things, but this concerning the case of Zongo. But in Konate, in a nutshell, that was what the court considered. It's a length explanation, but I tried just to take parts of it. Thank you. Yeah.
No, thank you. That was very interesting and very important. Thank you for that. What I would like to do with our remaining time is ask the Honorable Manrique to talk about not only the criminalization of speech, but use the opportunity to also speak about the safety issues briefly as well. As you mentioned in your introduction, it is, as we all know, it's very difficult to have a free press without a safe press. And there's an important legal framework in place in all of your courts about protecting the safety of journalists, which includes the protection and the need to investigate against attacks. So if I can turn it over to you, please, to discuss from the Interamerican Court, Honorable Ricardo Perez Manrique, both issues, the safety, the importance to protect and investigate, and also any words you would have to say about the criminalization of speech as well.
Okay. I have heard with attention the presentations from the colleagues, and I want to stress that in the Inter-American System for Protection of Human Rights, Article 13 of the American Convention establishes the right to freedom of thought and expression, defined as a right to seek and receive information without any restriction, and as against Article 19 of the Covenant of Civil and Political Rights, Item 2 of Article 13. There is interpretation. I don't know, there's a technical issue because I am interpreting. I don't know what. Can you hear me at the podium? Good. I don't know who's speaking right now. It's somebody with Mr. Manrique. We were saying that in the American Convention of Human Rights, as against what occurs in Article 19 of the Covenant of Civil and Political Rights, there is a total ban of prior censorship. And vis-à-vis this absolute ban for prior censorship, we only admit later responsibilities due to the exercise of freedom of expression. There was a case of prior censorship called The Last Temptation of Christ. The Last Temptation of Christ versus Chile, whereby the court ordered a unification of internal legislation enabling prior censorship. But speaking of later responsibilities, according to the Interamerican Court, are under what is called the three-part test that is in agreement with the other courts present. The three-part test consists in a restriction to freedom of expression must come from a law in the formal and material sense. B, must respond to a legitimate aim that may be protection of national security, public order, health, morals, and the reputation of other individuals. And last, must respond to a proportionality test, necessity and appropriateness, because that measure, the restriction to the freedom of expression, must be appropriate to protect the right vis-à-vis the freedom of expression that is at stake. Vis-à-vis certain discourses that are not protecting in the American court, hate speech, speech in favor of war, or illegal actions aiming to exterminate certain social groups. The Interamerican Court has prepared a case law regarding this item, first related with the matter of defamation and particularly an eventual criminalization of speech when we're speaking of reports against public authorities or people related with public causes. There is a precedent from 2019. That's the case Alvarez Ramos versus Venezuela, whereby the court has decided to exclude categorically the possibility of penal prosecution in relation to the protection of journalists in relation to public officials. That is, when we have a report related to a public official or periodistical journalistic versions are published about public officials, the court has stated that in this case we should exclude a penal response. According to courts, when taking into account the different resources in relation to later responsibilities due to the abusive action in the freedom of expression, the prosecution is only a precedent in exceptional cases where it is strictly necessary to protect an urgent social need. In this case, a discourse protected due to its public interest, for example, the conduct of public officials when exercising their functions, there the punitive response, a sanction, a criminal sanction, isn't conventionally, according to the court, appropriate to protect the honor of the public official. In the case mentioned by our chairperson, Palacio Urrutia, the court indicates that the recurrence of demands, the recurrence of public officials promoting demands vis-à-vis, I'm sorry, I missed the word, because with reports due to defamation or not with the aim of having a rectification of silencing the critics conducted regarding their actions in the public sphere, is a true threat to the freedom of expression. In this sentence, 2021, we have a first approach to the conceptualization in case law in the court regarding the obligation of states to protect freedom of expression via anti-slam measures, that is, measures aiming to protect public discourse conducted by journalists or communicators aiming to prevent these people who report public officials may be persecuted due to recurrences or resorting to demands or claims to try to silence them and prevent criticism. let us recall that the function of expressing an opinion and providing information, be it as a journalist or as a communicator or as a citizen that just wishes to share their views, shouldn't in any way be restricted when we're speaking of public officials, as the court stated, but also these persons' function demands that they shouldn't be claiming constantly in court to justify why they said or published certain things. This anti-SLAPP position has been taken by the European Human Courts. This line in the memo cases versus Russia in relation to the European Court in relation to demands of smear campaigns in a specific case. The Interamerican Court considered that these measures are addressed to prevent that the establishment of later responsibilities will enable claims of other judicial actions with a practical effect of excluding journalists or other individuals who speak in the public sphere. Article 13 of the American Convention doesn't consider this possibility, but it is fundamental that the interpretation of the scope of the convention be addressed to have a useful effect in their provisions. These demands of SLAPP are against freedom of expression, so Article 13 of the convention should be in agreement with the current demands for protection by journalists and communicators. And we need to protect the freedom of expression, furthermore considering the importance of the protection of the task of journalists and the media for democracy and pluralism in our societies. The court dictates a non-repetition measure where we have orders to states to adopt measures enabling removing the obstacles that enable violation of human rights. In these non-repetition measures, the idea is that the states must create alternative mechanisms to the criminal pathway so that public officials have a rectification or response when their honor or name has been harmed. For example, in the case Alvarez Ramos, it is prohibited to use criminal law to demand protection of honor or of the name of public officials in relation to their interventions as public officials or the administration of funds of public origin. In Palacio Urrutia, it was established also that there's a reference not only to the criminalization or sanction of discourse through criminal sanctions, but also the need that these civil sanctions be proportionate and shouldn't imply consequences that, for example, derive, as in the case of Palacio Urrutia, with the closure of the media involved. I want to end stating that in the case of discourse related to actions of public officials, as such, related also with actions taken in the exercise of their functions, according to the Interamerican Court 2019, the criminal law is not appropriate in relation to the respect of human rights. It will only be used in hate speech or discourse calling for violence. And in the Palacio Urrutia case, we also refer to the characteristics of civil sanctions. It is understood that we can rehabilitate and respect the right of a public official via the right to rectification of response and via civil responses. In other words, this issue about criminalization of speech is very important because authoritarian governments seek to silence critical voices of journalists and communicators and individuals that have a view about the reality, using criminal law as an element to silence and apply mouthpiece to the media. Thank you.
Thank you very much for that discussion. And I wish we had more time to hear more from this panel, but unfortunately our time is out. So I would like to thank very much this esteemed panel for joining us today, and thank you also for all the work you do in your courts on behalf of freedom of expression. So thank you, everyone. Thank you to UNESCO and to our host country. Good evening.